Okay, again, welcome in the lecture. As I have cited that this is basically of the synopsis, the background object of the law, characteristics of the act also, division of act, definition as prescribed under the act. This is the part whenever you are going to discuss any matter or writing the synopsis or the dissertation, and in PhD also a research paper, it requires to make the synopsis. Unless the synopsis shall not be there, it shall be very difficult for the students and for the researcher to write it systematically, and the findings will not be come out. At the same time, the another problem will be related to this, basically of the that to search the relevant aspect of the particular issue which is going to be written by the student. Therefore, the division of the act is also there, one of the synopsis. Definition as prescribed under act, as I have said that there is very relevant point relating to the definition clause, and unless that we will not understand about the definition, it will be very difficult for us to apply the words as prescribed in the particular act. Therefore, always try to read, study definition in detail. Sorry, in detail. Otherwise, this will create some problem in future for the understanding of the particular act. Definition is one of the characteristic, and this is also, you can say, the part of the synopsis. Prohibition of misleading advertisement. This has been challenged in the Hamdard Dawakhana, and in detailed discussion we will do it on the particular issue, that is the prohibition of misleading advertisement, and challenged by some company before the Supreme Court, and the Supreme Court's observation, it has seen that whether this has been declared unconstitutional because of the unconditional delegated legislation and the rules made thereunder. Prohibitions of advertisement of certain drugs for the treatment of certain disease and disorder. Prohibition, of course, section 4 and 5, 6, 7. 7 is related to the penalty, but the 4, 5 and 6 says that the any advertisement which is prescribed under section 3 shall be prohibited. We will discuss that one, and a penalty as a synopsis part of this aspect is there under the section 7. Power of the entry to search, because if the authorities will be there and government appoint the any officer for the searching whether they are keeping the objectionable item in their company or in their drug factory, and the power is also given to search that institution, that industry or that factory where the objectionable items are going to be published, going to be manufacturing by the company, that that if that will found, that will be seized by the officer authorized by the government on this behalf. Offenses of the company, because if the company, there are two kinds: one individually committed the offense, another is offense committed by the company, and for the company there is a common seal, and the concept of the lifting the corporate veil is one of the aspect is also there. Offenses of the company shall be treated separately. This is another silent feature of this act. Nature of the offense also. Nature of the offense, this is also the relevant aspect. Jurisdiction, try to offenses. Who will try this jurisdiction? Because the judicial magistrate first class have the power, but there is some provisions written in the CRPC. We will discuss later on in detail, but this is the part of the synopsis. Forfeiture of the items, goods that shall be destroyed. Offenses deemed to be a public servant, as you have seen, and indemnity relating to this aspect is also the very relevant point. It means indemnity means the immunity. Immunity. It is not a indemnity as written under the Contract Act, but indemnity is totally different from this aspect. This is the immunity. If any person, member, and any other officers has worked within the capacity of the legal provision, then the action shall not be taken against that person. This is called the indemnity clause is also there. Other laws affecting provisions are also there. That other laws will not affect this law. This is one of the aspect. Therefore, these are the points which requires to be discussed under this one. Saving clause, it is normally everywhere a saving clause at last. If any law was existing before that law which is in question or which is the subject matter of the discussion, saving clause, it should be in your mind that what is the meaning of saving clause. Saving clause means whatever the proceeding has been taken, that shall be protected, and this law shall not affect so this law shall not affect the earlier decisions and the action taken by the any authority under the provision of law. This is called the saving clause. Means that whatever has been taken earlier, before the making of this law, before enacting this law, that is protected. That will not come within the question according to the provision of this law. This is called saving clause. In every law, at the last, there is a provision for the saving clause. Power to exempt from the application. The exempt some issues can be exempted. This is also the power. Power to rule making. This is the very essential item in every act. And in the same way, here is also the provision under the that law prescribed some issues which says that the power to basically of that matter which is said that this rules shall be made by the executive under section 16. This is the last section of this basically of this act, and one schedule is there, and schedule's relationship is with the section 3. What medicines shall be restricted or what medicines shall not be permitted for the purpose of the advertisement. This is the basic object and the subject matter of the schedule. And the rules made under the act are in question because these rules has been challenged by the some company, and we will discuss this portion also either today or tomorrow, but tomorrow will be the last lecture in this matter. Judgment of the courts relating to this act in constitutional validity shall also be discussed with the matter of the some rules background on it. Therefore, these are the silent features as you have seen of the this act. The first point is background of this act to control unrestricted activities as a right, because to advertisement, as you have seen and we have discussed a lot, and various lectures I have delivered with reference to the article 19(1)(a) of the constitution, whether this comes within the speech and expression, and conclusion was there that in the matters of the expressing, if anything is going to be advertisement either for the purpose of the business or beside the business, and directly indirectly it covers within the parameters of the article 19(1)(a), and the restrictions can be imposed by making the law on the basis of the article 19 clause 2. This we have reached in that conclusion. Therefore, the control unrestricted activities as a right is under this protected clause of the constitutional law. But another side, whether this right is unrestricted, whereas there is 19(2), and the power is given to the legislature to make the law. In democracy, everyone have the right, but balance of right is required. One side the rights of the public, another side the rights of the businessmen. Everyone have the right, but there should be the basically of the use of this right for the general interest. Individual right cannot be prevail over the rights of the public. It cannot be prevailed. Therefore, balance of the right is one of the background. Therefore, thus the 1954 Act has enacted. Elected government have the power to control, basically to control the activities of the businessmen, because the business, why the businessman is there, business is there because it is for the betterment of the society, so that the everyone can get the items which the company factories are manufacturing, and these are for the society. Therefore, who will control to them? That will be controlled. As you can see, the before the 1986 there was no rights of the consumer, because one of the maxim was there, the caveator imperator written in under the Sale of Goods Act. No rights of the customer, no consumer rights were there. Only the rights were of the businessmen and traders had protected by the law. I am talking about the 1986. These are the rights, because it is the duty of the consumer to purchase the goods according to the that efficiency, according to that quality, or their that strongness, and whatever was there, it was the duty of the customer earlier. But the moment it started, and the public movement demands that there should be the protection, legal protection to the rights of the these customer, which is called the consumer. And now you can see the various times the Consumer Act was in the amended in India up to 2019. A complete act was enacted or amended and repealed earlier act because of the demand of the society, when there was the laissez-faire era. And at that laissez-faire era, there was the protection of the businessmen, because the capitalism was there in 18th century. So therefore, my point is that it is the duty of the elected government to have the power to control the activities of the businessmen. That is the power of the elected government, because the government which has been elected by the people in a democratic system, that is the government for all, including the businessman. Of course, one side there is a rights of the businessman as protected under Article 19(1)(a) of the Constitution, and there is a law for the protection of the rights of the businessman, and 19(1)(g) is also there to carry the business, trade and commerce, so on. But at the same time, the balance of the rights, one side there is a rights of the public, another side businessman right. If the quality items or the articles and goods is being produced and is being manufacturing, then there is a demand in the society, and the customer and consumer shall be already protected in their rights also. They will get the good quality items, because there is a need of that item, and it is being manufacturing by the businessmen, traders, and the traders are also protecting the rights of the consumers. But at the same time, if there is the monopoly of the businessmen, then elected government have the power to control the activities of the businessmen. And in the same way, relating to the advertisement, check and balance theory is also there. As I have said, that both have the rights to make it balance, and there should not be interfere and invasion on the rights of that businessman, as well as the rights of the customer. Thus, it is a duty of the legislature in a democratic pattern of the society, where there is a constitutional democracy, to make the balance in between two. Quality ascertainment method should be there. If quality ISI mark is there, and the maximum price is there, retail price is also written there, manufacturing date is also written there, all these quality ascertainment method should be adopted by making the law. Therefore, only the advertisement is not sufficient, but to follow the norm, that is also the one of the part of this legislation, which is going to be discussed with the help of the you people, you know that. Then come to the that 1954 act, which it says, we have seen the synopsis, we have seen the background, and we are just entering into the object of this act. And the name of the act is the Drugs and Magic Remedy Objectionable Advertisement Act 1954, Act number 21 of the 1954, and assent, as you have seen, that 30th April of 1954. What is the object of this act? And always, if you will see, the object of the legislation shall be written in the beginning before the section 1, but sometimes one and a half line and one line may be there without the object of the act. Then how you will search the object of the legislation? It is the duty of the basically of the student and researcher, or the student who are studying in the PG level, to search the object of the legislation. The technique for searching the object of the act is that read whole act, first to last, section 1 to last section. If there is some rules, then go through these rules also. And if suppose there is a annexure, there is a schedule, then try to understand this schedule, this object, then other parts, and then think about it, the why this act has enacted. This is called object. Why this act has enacted? What was the problem? And how this problem has solved by this act? This is another point. And what are the essential basically of this act, so that it can be said that it is an object? Why this act has enacted, number one, and what are the basic features of this act? So that, for example, here the section 3, and object is to prohibit and to control all the aspects which are related to this matter, which says that the object of the act can be searched according to the provisions of the law by going the detailed study of the act. If the object is written in the first paragraph, there is no problem. If there is written that this is enacted in the year of the Republic India on such and such, and no object is there, then requirement is to study the complete act, the whole act, and it requires to be completed in the manners, so that it can be said that the act have some object, that after the complete study of the act, it is a matter of the that issue. And this, the object of this act is, says that the control the advertisement of drugs and certain cases. First object is control the basically of the advertisement, to control it. And how it can be controlled? It can be controlled to impose some restriction. This is the first object. And second object is to prohibit the advertisement for certain purpose. If it is a magic advertisement, if it is a false advertisement, if it is a misguiding to the public, and if it is not in public interest, if it is harmful, as you have seen that the censorship, even if the can be imposed, some grounds we have discussed on Saturday of imposing some that the censorship, and these grounds are harmful, dangerous, not in the interest of the public, and it is magic, and it is harmful for the body, and it is very, very high price are there, no control over the price. And to control the price, it is the duty of the if you will see the legislation executive. The price cannot be fixed by any company, by manufacturing company, or a company who is the producing the items. That cannot be fixed by that institution, which is in the form of firm, company, factory, whatever is there, that can be fixed by the executive order under the legislation. But another side, the laws shall not be given to the manufacturer, and the raw material cost and the labor cost and the profit of the manufacturing company shall be taken into consideration at the time of fixing the price. And uniformity of the price will be there within the territory of India. It shall be the uniformity. If it is going to be exported, there will be the fixed price for that. If the any item is importing by any businessman from the other countries, there will also be the fixed price. And the Customs Act of 1878 provisions shall apply for that purpose. Therefore, the prohibition, the advertisement for certain purpose, that cannot be unrestricted, unfettered. Yeah, that is, you can say, the fanciful manner. And it is not depends on the mercy of the businessman, but the businessman shall not get the loss. That should be taken into consideration also. If the businessman will get the loss, then it will be ultimately the loss to the public, because he is a good businessman. He is supplying the good items. He has the good reputation, and he has also the constitutional right. That will also be violated. Therefore, Hamdard Dawakhana is a businessman in this case, and challenge these rules, and as well as the Section 3 of this Act before the Supreme Court, that this is the invasion and interfering in my rights, constitutional rights to carry the business. Business is very essential for the health of the economy of country and for providing the facility to the people of the country. Thus, object of this legislation is to prohibit the advertisement for certain purpose. Remedy is alleged to possess the magic quality. As you have seen that if one person will use in one time, he will become the young man. Suppose he has crossed the 60 years age, he will be like a 20 years age of young man. This is called the magic. No medicine can be manufactured by any company, any businessman, any item to change the natural system. As we are facing at present, you can see the pandemic problems. And this has been started from the December 2019. And this is the 8th month of the 2020. Near about the 9 months we have completed as a global human being of the society. But still there is no vaccine, no proper medicine, nothing is there. But everyone is searching, scientists are searching, they are working hard for that. So magic cannot be said that it will be immediately done something about it. Remedies alleged to possess magic quality, that is prohibited. Provided matters, the many FIR has been lodged by the persons if any thing was advertised through this making the medicine of this prevention of Corona-19. FIR has been lodged because of the act are existing. But it can be the efforts can be done by the persons for manufacturing the medicines, but experiment system is there. You will see that all these parts under the section, the definition section also. So remedies also requires of every disease, but in a way of the experiment of particular medicine. Provided matters connected therewith means one of the objective which is written in the first paragraph of the act is that if these are not complete as cited, that the control to advertisement and for certain purpose, that purpose may be magic, that purpose may be that to earn the money very soon, or a without following the standard laid down by the executive order. These are all these things. Provided matters connected therewith, like that, if any matter is there. Question of delegated legislation is also one of the part of the object of this legislation, because in the sections it has been written that the quality of this medicine or anything shall be taken into consideration. Therefore, whether the delegated legislation which has made by the executive is under this purview of this legislation. This is one of the object of the act. Now, what are the characteristics? Because I am just narrating the things in a simple manner, not in a manner as we are discussing in the classroom, just making the points. And these points are useful for the LLB students also. Point wise, I have made the slide for the LLM second semester student. No chapter is divided. Very interesting is that, as you have seen that there are the 16 sections. We have seen that there are the one schedule. And in every act, if we will open the act, there is a provision to make the basically of the chapterization. As you know that just I am showing you about this basically of this is one act, and in this act there are the chapterization. It is going to be end, but I will take the class, another class. It is going to be made the chapterization. You know that there is a chapterization of the system of writing the legislation. But interestingly, in this act, 1954 act, which is known as the Drugs and Magic Remedies Objectionable Advertisement Act 1954, had no chapterization. If there is no chapterization, how one can assess the characteristics of the Act 1950 Act, 54 Act? How it can be assessed? How it can be said that what part where is? Who are the authorities? Who have the power? And what is the main provision? What is the prohibition? And what is the penalty? What is the miscellaneous provisions? Because there is no chapter. Chapters are not there. Then such form was, it is a act of 1954, having the 16th section. But this is not the subject matter that if there is no chapterization, it doesn't matter. It is not a matter that there is no division. Automatic division is there, but not written the chapterization. And one of the characteristics is that no chapter is divided, no chapterization is divided. Chapter has not divided. It means, but the writing of the legislation of writing method of the legislation by the legislature was there without dividing it into the chapter. Total number, as you have seen, one schedule you have already, I have said about it. Without dividing the act into chapters, still there is a silent feature of act which is called the division of the act. Silent feature of that. One and the first portion always is there related to the section 1 and 2. There is. First is the name, we will see. And the second is the definition. From third, the offenses. Third, fourth, fifth. This is up to the third chapter. It can be divided by ourselves by applying the mind that from which portion another chapter can be made. If you will be able to, or you will be in position to understand, to make the chapterization, that will be very easy for you people to write the assignment and dissertation research paper. Because in your mind that whenever any nature of the provision comes, any different nature which was not directly related to the earlier chapter, the chapter will be changed. If any matter will come to write it which have no direct, I am using the word the direct relationship with the earlier heading, then automatically the heading will be changed. If one point have no directly relationship with the first point, then second point requires to be made. Point number 2, point number 3, point number 4. Division of points means the indirect relation is there. Whole act have the basically the direct relationship. Whole act have the direct relationship, but sorry, indirect relationship whole act have, but direct relationship will not be with the first segment of the act, with the second segment, and segment means the chapter. In the same way, making the points, this is the research method, and this research method should be kept in your always by the student in the mind. If anything is coming new, and the immediately the paragraph should be changed, another point should be made. If there are 10 points related to the same nature, there should be one chapter. That is called the chapterization. Because if the chapter is not given by the legislation, it is the duty